Good morning, everyone. Thanks for joining us today to discuss employee separations, compliance and strategy, and mass layoffs. I'm Kate Townley, and with me today is my colleague, Kristina Grimshaw. We are from the law firm Florentino and Grimshaw, a New York-based labor and employment law firm, and we're very excited to be here today. So before we dive in, I just want to note that this presentation is for informational purposes only. The material discussed herein should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are strongly encouraged to consult a lawyer concerning your own situation and any specific legal questions you might have. So today we're going to be focusing primarily on the second and third items on the agenda here, group separations, RIFs, mass layoffs, and the federal and state WARN Acts. But first I'm going to touch briefly on individual separations. And the reason for that is because very often the considerations that come into play when deciding whether or not to separate an individual employee will come into play when you're considering whether or not to include a given employee in a group separation. So it's really important not to view any of the items we discuss here today in isolation. And feel free to drop any questions you might have in the chat. We have a lot to cover today, but we'll do our best to get to any questions at the end. And without further ado, so when it comes to voluntary separations, here on the screen we have some key considerations for you. And I think one of the things that we want to highlight here is that while an employer can't necessarily dictate when an employee gives notice of their intention to leave an organization, they can control how an employee spends their remaining time, how they're prioritizing work, transitioning work rather than taking on new work is often prudent. And in New York, employers can actually incentivize employees to give more notice by conditioning payout of any paid time off on the employee having provided adequate notice. Other states, however, require the payout of PTO, so conditioning PTO payout in that way would not be acceptable. And of course, you want to ensure that